Good evening, everyone, and welcome to tonight's celebration book launch. Sorry, I just have to remember my phone so I keep time. Of Lutz, my dear colleague and friend, Lutz Oette, whom I've had the pleasure of working with since coming to SOAS 6 years ago, and who we together co-direct the Centre for Human Rights Law, as all of you are well aware. We're joined tonight by Professor Carla Ferstman, who is also a dear friend and good colleague from my time in Cambodia, and Lutz has also worked. You were his boss, weren't you? For several years at REDRESS. You are now a professor in your own right at Essex University, and your book, published with Bristol University Press this year, is about
It's about detention.
Yeah, extradition and detention, yeah. What's the name of the book again, if you remind me, Carla?
Conceptualizing Arbitrary Detention.
Yeah. So obviously, with your experience also at REDRESS, is a very good discussant to have on the panel tonight in terms of your own experience and research in the field in relation to torture. So we wanted to structure this as a discussion or conversation or dialogue between the three of us, with myself probing Lutz with some questions, which would then lead to the conversation, and Carla coming in as she sees fit. We imagine this to be an ongoing discussion for around 50 minutes, and then we'll open it so that everybody can join us. If there's something desperate that you need to say beforehand, please do raise your hand, and I'll do my very best to include you regardless. I think the wonderful thing about reading a book that's written by a friend and colleague is that you have their voice in your head while you're reading the pages. And so a lot of the time it felt like I was talking to Lutz while I was reading his book. I'm going to ask you what motivated you to write the book, but I wanted to start with what I found interesting, shamelessly putting myself first. The book for me is both an elegy and an ode. It's an elegy, which of course is a serious reflection, typically a lament for the dead, to the state's and others' use of torture, bringing to life the human face of torture, making it real and embodying its practices by focusing on its legal gradations with precision, humanity, and care. I wanted us to begin by discussing how you do that, and then move on to what I see as the ode, namely a dedication to the anti-torture movement and a dedicated commitment to justice for torture survivors, through your explanation of how both that is happening through the Prohibition's praxis and might yet come about through its expansion. So before, and I think Lutz in his own right is a poet, and has in effect also published poetry. So I thought it was also, with gesture to both elegy and ode, I would begin by what I see as a stanza from your poem, Sudanese Journeys of Friends, Nightmares and Dreams, which really speaks to this idea of the dark side or the elegy of torture. The fourth floor. The weather isn't nice today, he said. It's never nice on the fourth floor. But the ignorant outsiders had to be told, as they wouldn't get the usual treatment. Others needn't hear the weather forecast. The dread of naked power being wired into the collective psyche, being taken to that floor, one cannot expect to get off as lightly as we did. So Lutz, what motivated you to write this book? Why this book, and why now?
Right, thank you for this wonderful introduction, Michelle. Really took me back, obviously, to the time in Khartoum, because that was based on an actual experience and took me back to my days at REDRESS. And if you talk about what motivated me to write the book, it was a book I have been wanting to write for a long time, and that I thought I also owed to myself, having worked in the field for so long, really to bring my experience together. And really, I think in terms of its genesis, it started right after 9/11, 2001, because as Carla will remember, well, that's when I joined REDRESS. Carla had joined, I think, a few months earlier as the legal director then. And obviously that was really a momentous challenge for the prohibition of torture and international human rights more broadly. And we were really at the thick of these developments at REDRESS, having to also go out and defend the prohibition against all sorts of challenges. I think we were also one of the first organizations that wrote sort of an in-depth analysis of counterterrorism and torture at the time. But I think that period also had a lot of opportunities for a small organization like us, because I think we were really at the forefront of a lot of developments in terms of standard setting, new ways of thinking, be it on universal jurisdiction, victims' rights, before the ICC, the right to reparation for torture, implementation of the Istanbul Protocol. So a lot of these activities we were really quite intensely engaged in, and that also was an opportunity for me then to work in the field, to meet all sorts of people, torture survivors, activists, officials, and having often very robust conversations on many aspects of torture and the legal interventions that we pursued. And obviously that made me reflect a lot about the work we did and about the role of the prohibition and the law. But I didn't have any time really to reflect beyond the immediate day, and that also was one of the reasons for me going into academia, thinking that I would have plenty of time. Well, I was mistaken, but I eventually found the time. So, no, but joking aside, I think when I went into academia full-time in 2015, so I think then I looked more into some of the marginal or marginalized areas of the prohibition, like issues such as poverty and torture, how they relate to each other, which were sort of a bit off the beaten track in terms of the mainstream focus on torture. And all the while I was thinking, so what is the kind of book I can write to bring all these experiences together? And then I found the transformation to be sort of the best possible frame, because it allowed me to write a bigger story, to look back, reflect on underlying assumptions, to critique them, to look at where the prohibition is at right now, what are the distinctive features of these developments and where is it heading. And that basically was the key motivation. Why now? Because eventually I found the time. We have a new module on the prohibition of torture, which I'm convening since 2022, so that's an added motivation to have that as a quasi-textbook, which is very handy. And I think it also will make a genuine contribution to the field, because even though there is a lot of brilliant literature on torture, I don't think there's any book that has sort of that kind of sweep what I've attempted to really engage with. And I have to acknowledge, and I did that also in the book, a lot, especially of the younger scholars in the field of torture. I mean, across disciplines, not only in law. It's really amazing to engage with that work, and that was actually for me also the beauty of the research. And I was still engaging with people who are more sort of in the old mold of the mainstream focus on positivist torture. And then when I told them about what I'm doing, they were like, is that really out there? And then I sent them the literature list, and they said, okay, yeah, there is more to what we know in our everyday work. So that's also what I tried to reflect in the book, yeah.
Yeah, and I think you did that incredibly well. But let's take us back to that foundational moment then of September 11, 2001. Can I just get a raise of hands? Who in this room was born after the 12th of September 1995? Why do I say 1995? Well, you know, scientific cognitive development suggests that we know who we are as human beings by the age of 6. So around the age of 6, you detach from your primary caregiver. So those of you born at that age have lived your entire lives under the war on terror, war against terrorism. And so for me, I mean, for many of us who remember the days of analog even, guys, so cool, it was obviously a pretty big juncture. But I wanted to ask you, why is that such a key moment in the transformation of the prohibition against torture? As you say in the book, the war against terror, or the war on terror, has precipitated Janus-faced consequences in that it has generated legally ambiguous practices that may facilitate torture, which threaten to add shades of grey to what should be the monochrome picture of the absolute prohibition. So could you describe a bit further for us why you think the war on terror had this effect, and what these legally ambiguous practices were or are, both in the US and more generally?
Yeah. I mean, obviously, because I made that the first chapter, the war on terror, and it's probably the least original chapter, because a lot has been written on that, but I still thought that it needed to be there, because had that major challenge to the absolute prohibition succeeded in the war on terror, then the rest of the book would have looked very different. So I think it was a major sustained challenge to the absolute nature of the prohibition. It's not the first one. Obviously, the country that has sort of first directly challenged the absolute prohibition was Israel with the Landau rules, the moderate physical pressure, and then following the Supreme Court ruling, also the recourse to the necessity arguments. So that was always recognized as actually challenging the absolute nature of the prohibition, because this ran counter to basically Israel's international law obligations. But Israel was always seen as an outlier at the time, and what the war on terror did was basically that it was actually pursued by the superpower, had very wide reach and visibility, and hence major impact. And I think sort of there are three sort of key elements to when it comes to torture, the way I see it. One is the actual practice, because you had a number of torture practices, both like Guantanamo Bay as the quintessential camp, then you have had the clandestine torture centers, and then you had the renditions network, which brought a number of states into the fold. So you had a very intense exchange of torture practitioners, if you like. And that was an open secret, certainly after Abu Ghraib. The other element was the public discourse, the legitimizing discourse. So even if the US did not publicly claim that it was actually justified to torture, I think sort of the whole overall discourse and the popularization of these methods then meant that you had the ticking bomb scenario all over the place. And I remember one of our colleagues, poor Kevin, always had to then go to the media and defend the absolute prohibition of torture, because obviously the ticking bomb scenario, for those of you who don't know, is basically the idea that torture might be justified in exceptional circumstances where a bomb is about to go off. I mean, it's basically also designed to trick those who support the absolute prohibition into admitting that there might be exceptions. So it's also used as an ideological construct to, in a way, having the gotcha moment, and then say it can be justified. So it's a way of normalizing the exception.
But I remember that period. I remember it really well. And what was interesting at the time was that the Americans were really coming out and saying, well, actually, we need to torture. I mean, the semantics of what they said might have been a little bit more nuanced, but basically they were saying, you know, we can torture. So what were they doing in that statement? They were breaking down an absolute barrier on torture, but they were also dehumanizing vast segments of the society which they felt it was okay to torture. So that was really important. The other thing that I think, I agree with everything that Lutz said, but another thing which was fascinating was the amount of governmental cooperation. So all these states who were cooperating in what they knew was a torture regime. So the Lithuania, the Poland, all of these countries, Ireland, all collaborating with the United States with the view to the secret detention places, the rendition, Guantanamo Bay, which is still open. Right? It's still open. So all of that collaboration is something that somehow is not so much talked about anymore. And I remember when the first flight went into the Empire State Building, I was sitting in REDRESS offices, and I was in there we had an intern from the Gambia, and he was looking at the screen, and I was like, well, you know, get back to work. He's like, no. And then we were sitting together and we were watching the second plane, and it's a moment, because we have talked about it it's so long ago now, it's more than 20 years ago, still talk about that incident that day in the office on this tiny little computer, watching the second plane going in. And it was transformative from that perspective, both because the US was not hiding behind the smoke and mirrors, really, but also the state cooperation.
But maybe just to come in, because I mean, I think they were quite open about the methods they used, but in the legal discourse, they actually never said that or never admitted that they were breaking absolute prohibition, because they narrowed the definition to such an extent that they could actually claim that waterboarding is not torture. So waterboarding is basically sort of simulated drowning, and
torture is only those acts which result in organ failure or death.
Or lasting psychological damage. And they actually took
interrogation, wasn't it?
Yes, they took that actually from sort of emergency regulations, the text. So it was for a completely different purpose, and then applied that to torture. So they made this threshold so high that it was really only the most exceptional case. And with waterboarding, they said, it won't inflict lasting damage, and anyway it's all controlled, it's done in a scientific fashion. And in a way, this is an old colonial imperial playbook where it's the good people having to use, unfortunately, these methods, but they do it with the right intention in the most carefully controlled circumstances. And therefore, it's completely different to what the barbarians do. I mean, that is in a way the civilizational discourse surrounding the good torture, so to speak. And there was a lot of that. And waterboarding, obviously, I think that's where, I mean, what you said became so stark, because everyone knew it was torture. I mean, that's a well-known torture method from the Spanish Inquisition. Actually, a lot of US soldiers were actually tortured through what they called water torture by the Japanese in World War II. So this was well known. So in a way it was, I mean, they maintained the legal fiction, but everyone knew that these were bogus arguments. And they were mainly to sort of ward off any accountability at both in the US and abroad. Yeah.
So if I'm hearing you both correctly, or if I'm listening correctly, what you're bringing out of this is that September 11, 2001 and the war on terror perpetuated or reiterated what had already been practices that historically had been used both in colonial regimes and also by Israel. But the distinction for you is really how mainstream it then became, and the fact that it was being utilised not only by the US but then subsequently through extraordinary rendition and other practices endorsed really by quite a few members of the international community, so to speak, by states anyway. I mean, I think that takes us nicely then to this idea of who is being tortured and how, and the fact that your book draws out something which I think there's been less research and focus on, which is this idea of discrimination and the nexus between the idea of discrimination and torture practices. And I think it's quite remarkable in its breadth and scope in the way it deals with this. And to make it clearer, Lutz is really talking about the differentiated targeting nature and impact of torture on specific groups, which often goes unnoticed in the reported media, in the mainstream media. But as you argue, the separate and differentiated use of torture methods used against women, racial groups, and persons with disabilities have had a significant impact on how the prohibition is understood and is evolving. One of the key findings that you raise is that in contrast to gender-based violence against women, there has been no concerted mainstream effort to focus on racial discrimination in relation to torture. So if you want to comment more, of course, on any other aspect of the chapter as well, but for me, I wanted to ask, why do you think this is the case? What impact, if any, do you see Black Lives Matter having on this, and claims of recognition of racialized policing on this?
Right. Yeah, I think that the focus of the prohibition has always been on the torture. So I think the background was there that it developed against the context of political torture, torture in the criminal justice system. And there is an early commentary written by two diplomats who were involved in the drafting of the convention, and basically saying the convention does not say anything about the identity of the victims, translated into today's language. And I think that makes for some of the strengths of the anti-torture movement, because all torture victims or survivors, depending on how you want to call them and how they want to refer to themselves, obviously the legal terminology is victim, then in a way have something in common. And this experience of having been subjected to torture, to this existential experience where someone is subjected to a situation where they are under the total control of someone else and being targeted in their very sort of humanity. And that, I think, made for a very strong anti-torture movement, but still with a very inbuilt sort of male orientation, given the paradigmatic detention context. And I think it was then, especially sort of the feminist movement and the focus on gender-based violence that sort of broke that up and started to contextualize it. And I remember we had actually an audit at REDRESS in the mid-2000s, sort of a gender audit of REDRESS, because at that time, what is today sort of a given that rape constitutes torture, that gender-based violence against women or gender-based violence more generally falls within the scope of torture and other ill treatment, was not really identified as a particular strand. So that was evolving. So I think that it was a specific lens that then made people to focus on specific groups. And I think it has expanded then in terms of specific groups, which are now often referred to as vulnerable groups. I think the problem with this whole notion of vulnerable groups is that you obviously have these categories instead of looking at discrimination as a function and then to see how that impacts various groups. And I think when it comes to racial discrimination, Tendaya Chume had said that international law is colorblind in a way, so it's a more general problem, I think, with international human rights law scholarship and the anti-torture movement not having that specific lens. I think it's also an issue that you have very sort of different contexts where race plays a role. I mean, you mentioned the counterterrorism context, now you have the migration context, you have racialized criminal justice systems, you have racialized incarceration, so the contexts differ widely. And obviously you need to then put two and two together and say, if we look at it through that angle of racial discrimination, then it becomes very clear what the commonalities are. But that thinking has for a long time not been there. And I think also the jurisprudence has been quite sort of slow in picking up on the issue. If you look at the European Court of Human Rights, for example, the way to do it would be to combine an Article 3 violation on the prohibition of torture with Article 14 on non-discrimination. But Article 14 was not really applied consistently throughout, so it was very selective and not very coherent in how they approached it, and all of that contributed to, I think, the lack of focus. And maybe also the anti-torture movement itself did not develop sufficiently that focus. And I think the Black Lives Matter movement made a huge difference in terms of raising the awareness. In terms of the UN's approach to the issue, I think that is still an open question, because obviously the Office of the High Commissioner now has sort of a dedicated sort of thematic focus on that, but the US and others actually sort of watered down what Black Lives Matter and others wanted to achieve before the Human Rights Council in terms of a specific inquiry. So they have broadened it, and I think that could have been more specific also on the racial discrimination aspect, not only of torture, but all other forms of ill treatment that we're talking about. But I think a lot of the concepts they brought forward and the defunding of the police or the broad abolition movement, I think all of these are now live issues that make us think then differently about how we address things. And obviously on abolition, I had that covered in the second chapter, not under racial discrimination as such, but that's a huge issue now, the extent to which imprisonment in and of itself, because of who it targets and what kind of effects it has, should be considered cruel, inhuman, or degrading. Yeah.
Maybe just going back to the definition of torture, and I think you cover this quite well in the book. Discrimination comes in when you look at both the limits of the definition, which tend to focus you to the white male in detention, but also because there's the requirements of public officials in the UN Convention Against Torture. Torture is an act committed by public officials or with acquiescence. So that naturally puts you into public sphere, whereas when it comes to rape and gender-based violence, these are acts which often occur in the private sphere, so you have that natural limitation. But the second issue with the definition has to do with the notion of severity, which crosses. Severity is also something which is recognized in other forms of cruel, inhuman, or degrading treatment or punishment. There is a bit of a threshold issue with severity. But who decides severity? And that's a really important issue from the perspective of discrimination. So the judges, who are the judges determining whether something is severe? There's a reason why you're kind of taking your focus back to the white male in detention, which the judges can relate with, and other kinds of violence is less relatable to and is considered less severe. So think about the cases of forced nudity. Think about cases of slapping, like physical violence, but against persons with disabilities, against children. There's a range of different categories of people. We need to kind of disaggregate and look at the impact of different kinds of harms on the persons in front. The Torture Convention is quite static in that sense. That deeper analysis is not necessarily done, and the persons doing it are not necessarily broad-minded. So that what that means is that severity tends to be focused on the narrow categories that the convention was initially focused on. So I see the discrimination both from the text of the definition, but also how the definition has been interpreted. I also think it's important to look at this idea of like the horrible incident, which torture tends to be associated with. So we think of electric shocks, we think of, I don't know, really horrific incidents, but that mundane, other kinds of more mundane acts, which can be absolutely horrible, indefinite detention, absolutely horrible. But in a way, detention we don't really put in the same category, but it could amount to torture. But that mundanity is something which prevents it, because torture is something which is outside of the mundane. So that also, and also when we think about who is being subjected to who are the forever prisoners, then that brings us into a category of, okay, now we understand discrimination, because those types of acts are targeting specific populations. But the acts are not seen as extraordinary, they're seen as mundane. Mundane is not really something we connect to torture.
Yeah.
Maybe just to pick up on, because that goes beyond obviously the discrimination, but goes to the heart of how we conceive of torture more generally, which is very important. I think that the issue there is, as you said, the categories are actually quite simplistic. If you read them just in terms of, okay, we have certain categories of what we consider severe, and then we have formulas, subjective, objective elements of pain and suffering and cumulative impact. So these are all shorthands, but how do we apply them to any specific context? And I think Carla is quite right that that has been done in a way that it focused on the exceptional as a default, and then all the others were measured against that, and a lot of them for various reasons, maybe also because the torture movement itself and others did not bring that to the fore, were then not taken as seriously as they should have been. And there I think the literature now in particular is really challenging, I think, simplistic understandings. How Paris Salis has developed this notion of a torturing environment, looking at it much more holistically, also looking at psychological suffering. Ergun Kartal, who was here last week as a visiting scholar, who will be publishing his PhD thesis soon, hopefully, on the notion of psychological suffering. All of those scholars are looking at how we, for example, should look at solitary confinement, indefinite detention as equally bad. And in a way, in the book, I'm going further to look then at sort of the whole range of structural violence, which even goes beyond the direct intentional violence, and ask to what extent that should also fall within the scope of the prohibition. I mean, obviously, that's the next step, if you like. Yeah.
And to some extent, the next step in our conversation. Because I think we could talk a lot more about what you've just said in terms of both the structural implications and also understanding torture is far more present and prevalent in the mundane, the ongoing iterations, as you say, of arbitrary detention for extended periods or extended periods of low-level violence that then subsequently result in a form of intense suffering. But to move on then to the ode, to the celebration a bit of the anti-torture movement, but also thinking through legally and doctrinally how there are shifts and changes in how we understand torture, the prohibition against torture and how it can be protected in the current period. I mean, one of the things that the book does adeptly is situate this absolute prohibition within the paradox of civilizational discourse justifying it, and I thought that came out strongly in your discussion of Israel as the only state, as you mentioned, who systematically condoned the use of torture and torture-like practices against Palestinians in detention. But perhaps even more so when you discuss torture prevention and sort of this idea of the white male judge then somehow aligning himself with the white male prisoner. But you note, for example, that there are important shifts being made toward, as you've said, structural and situational understandings of torture, including what you say is a sophisticated ecological approach to torture prevention that seeks to avoid the shortcomings of both individualistic agent-centered approaches and overtly broad structural approaches. So this to me is a response to the shortcomings of an international legal paradigm that for too long made assumptions about who needed to be protected. Can you say a bit more about your views on this and why it might be important to focus on the new, what's the transformation looking like for you?
Yeah, so I think it's not only about the who is to be protected, but also about the how.
Yeah.
Because if you look at torture prevention, the whole idea of torture prevention is torture is exceptional. We then have a system in place of legal prohibition and the various protections, custodial safeguards, maybe visiting mechanisms, and then the state in these exceptional situations should then investigate and prosecute the perpetrators, should provide victims for the reparation. And where all of that fails is then third states can then exercise what is known as universal jurisdiction, so where torturers from another country are present, they should be prosecuted. So that's basically the idea. But obviously in a state where the rule of law isn't working, where the state is actually the main perpetrator of torture, as it by definition will be either as a way of a deliberate policy or for systemic reasons, then often that doesn't really work. And even where you have a state that is generally functioning quite well, a lot of people may fall through the cracks because of gendered, racial or other biases, or biases against those who are socioeconomically marginalized. So some of the safeguards may then work for the normal people, so to speak, the ones who are benefiting from that society, but not for those who are on the margins. And I think that's where where increasingly human rights bodies and researchers have realized that the assumption that the legal protection actually works well for everyone is mistaken, because there are obviously a lot of people who, and we've had that in a number of countries, Sri Lanka, for example, there was low-level corruption combined with torture, because it's actually the most poorest of society who are then basically exposed to this kind of pressure from the police. Even if it's small amounts, it's a systematic practice. And for a long time, all these other factors beyond the law and the institution were not really discussed much. As in the subcommittee on prevention of torture, the UN body, we have to credit them a lot with the work they did, because they said we basically need to open up the idea of prevention beyond the legal prohibition and the institution. We need to look at all the various factors. So they started looking at corruption. They started looking at inequality, at all the financial side of, say, prison systems, etc., and the various interests involved that basically fueled torture practices. And I think that's a new approach that really becomes very contextual. It looks at what are the local factors, institutional factors that contribute to torture, not only the legal factors. So that is a very important, I think, expansion of our understanding of how we look at torture. Basically looking at it from the bottom up and then say what is most effective in preventing it. Another aspect I think that is not really talked about much is that international law itself is often the problem. Because if you have, for example, in the field of international migration, the states have a lot of latitude when it comes to border controls, when it comes to immigration detention. In the counterterrorism context, states have been given a lot of latitude, extended detention and so on. And a lot of these are actually the settings, or at least the background conditions, which then expose people to torture as well. So I think international law should come much more into focus when we think about what would effective prevention actually entail. But that's not, often it's not even in focus, because it's accepted as being part of the overall framework, even though it might actually be the problem.
Yeah.
I would agree with all of that. And in terms of international law or the jurisprudence, if you think about the European Court of Human Rights and how it deals with different kinds of prohibitions. In torture, in a way, it's not the right one, because torture torture is absolute, so you don't have this balancing exercise. But if you remember what I said before, a lot of violations are not necessarily being framed as torture. So then the European Court of Human Rights has this balancing exercise. But then with it, it doesn't balance things in the same way, and it doesn't weight these things in the same way. So with respect to issues like border security or counterterrorism, national security, the European, if you read the judgments, some of them are shocking because they give so much weight to that and nothing to any of the other factors. So there's no way to overcome. But actually, there's plenty of way to overcome. But the judges are kind of, in a way, I mean, I think the whole European Court is, in a way, a whole balancing exercise, which is a broader discussion. But I think the issue is not just in the analysis of how courts interpret torture. It's about the broader legal principles around these cases, which are also privileging certain government actions, particularly when, like the big government actions. So the use of immigration detention, I think, is a great example. No one's really bothered by the length of that detention, actually. None of the courts, they're not so bothered by it. But when does it cross the threshold of being absolutely abhorrent of a practice where it should invoke our consideration of whether torture is at issue or not? No one's considering that. So I think these are some of the issues. So you have these big policy frameworks, and you can't really necessarily put them into the torture framework because the mechanisms, the legal mechanisms, like block you before you get to argue that in an effective way.
I think that's, yeah.
Can I just comment? I think the way to do it is probably really, I mean, as you said, to attack the underlying assumptions and the privileging of certain interests, and then say who is the prohibition of torture and ill treatment actually there to protect, and obviously, is it justified to make these differentiations? And I think that's where we as scholars and obviously practitioners have a role to play also in what Carla did in her book, to say, okay, arbitrary detention in and of itself should fall within the prohibition. This is also thinking in categories. Normally, as a lawyer, you'd think arbitrary detention, okay, is a matter of the right to liberty and security. You don't necessarily see it as constituting torture or other ill treatment. So I think we need to cross these boundaries and then look at the actual impact and whether it should fall within that. So I think it's also our fault to think along sort of rigid categories and not cross the boundary and think more holistically about what should actually constitute a violation.
But also remembering that it's not all acts of arbitrary detention which are going to be torture. Every act, it happens within a context. Mm-hmm. So I think there's some forgetting about that. In fact, what's happening is that there's an exclusion of whole categories from being considered as, well, maybe it is or it isn't. No one's considering that. Whole categories of behavior are being excluded because they are actually the basis of laws properly enacted by states, which then gives another flavor of acceptability, legitimacy to them, so that they're not being challenged in the same kind of way. That would be my view on that.
And this is a wonderfully segue into all my questions, because does this at all then reflect the carceral turn in human rights? This idea that human rights increasingly have been aligned with the carceral nature of the state and criminalizing activity as being a kind of legitimate way or means of ensuring that certain rights are being protected while others are being completely stripped of them. I think that came out strongly in your book as one of the questions to be thinking about. You suggest that criminal accountability retains an important symbolic, official and public repudiation, deterrent and justice function, which needs to be centered in a widened field of vision that would include a relational approach to torture survivors, both direct and indirect, and perpetrators, that would approach safeguarding the prohibition more holistically. So you're not saying that it's an either-or. You think there is a role for criminal law and criminal justice. It's a both and, but it's got to be more holistic. And you draw quite a bit on anti-torture NGOs, including Dignity, and many key scholars here. But can you see, going to the transformational aspect then, do you have sort of final thoughts on how that might occur in the current moment? And if you want to talk a bit about the ways in which torture itself is changing. We're coming up to 6 o'clock, so I feel like I need to let the audience speak.
All right. Yeah, I mean, maybe I need to say a bit about the relational approach that I set out, because that's sort of how I develop my understanding of torture in the book. And basically, it's seen as a function where you have an extreme power asymmetry that is actually being abused. So it's a relationship of dominance, and obviously it's not only an individualized relationship, but it has sort of several, it's a concentric one where you have the individuals, but also relatives, you have whole communities that are impacted by it. So I think we need to also then broaden our understanding of the way those in a position of dominance use torture and other ill treatment to produce or sustain their dominance through the infliction of extreme pain or suffering or degradation. And my understanding of accountability is then, how do we then, through accountability mechanisms, actually address this power asymmetry? How do we, in a way, make the people who are responsible, both individually and institutional, account for what they have done through their dominance? So that also means trying, obviously, in the process to reverse that dominance for good. And I think when it comes to impunity for torture, it is a very important, if you like, pillar of the anti-torture work. It has now run into trouble with those who call for abolition, because they say that it's the wrong approach. But in the field, for a lot of people, especially in countries where you have these power differentials and where those people who are at the receiving end of torture are exposed to it are the ones who grapple with the criminal justice system, and those in power actually get away scot-free with all sorts of crimes. That has a powerful symbolic function. So I think it's not only the actual incarceration, but it goes beyond that you change these power dynamics. And I think there are also quite sort of progressive ways. I've been sort of in conversation with an Argentinian prosecutor, and in Argentina, for example, they've broadened criminal accountability to also make it more institutional, in the sense that if you have a prison director, for example, they are held accountable now for failings within their prisons where people are being tortured or ill-treated. So then, if you have a system that is actually working, then it could be an actual deterrent. So that is very important. And for victims, I mean, that goes beyond accountability, but it's also reparation. It can be a very powerful experience, also symbolically. We had a meeting in Trujillo in Peru with Azul Rojas Marin. It's a very well-known case that was before the Inter-American Court of Human Rights. Redress was also involved in that. It was actually someone who, at the time of the rape, it was a baton rape, identified as a man in Peru, who's now a trans woman. And she came to that meeting and then spoke about this ceremony they had on the state having to apologize. So that was one of the few reparation measures that Peru has so far implemented. And one may think that is a very soft thing to do. It's basically in a big hall, they had a large panel, and then various ministers had to line up and basically acknowledge what happened and then apologize on behalf of the state. But listening to Azul, that was a very powerful moment also of turning the tables in a way of redressing that power imbalance. And you may say it's only a moment, But depending on how that is picked up in society and if it triggers sort of wider debates, that can be also powerful beyond what it means for the individual. But obviously that is very important in its own right. Yeah.
It reminds me of another case we worked on, which was an individual from Chile who was tortured, was beaten so badly that it affected his cognitive abilities. He was one of the people who was put on a boat and ended up in the UK. He, for his whole life, was afraid to go to the Chilean embassy because of his association of his past experiences, and despite changes in regime, etc. I remember, so he also got his decision from the Inter-American Court of Human Rights, and we arranged a ceremony at the Chilean embassy where he was physically handed his very insignificant financial reparation compensation award. But it was such a moment of pride. It was the most incredible experience. And these things are really rare, but when they happen, they're quite tremendous. Another client of ours who had a positive human rights committee decision, which is basically declarative and didn't result in anything kind of tangible. But I remember speaking to him, and he was tortured in Cameroon, and he said, well, you know what this paper, because all it was, you know, the paper, the decision, you know what it does? I give it to my friends and my family. Now they understand why I am the way I am. And it sounds very insignificant, but actually, no, it was tremendous, tremendous.
Yeah, because obviously if we see torture as being about dehumanizing someone, then reparation is about rehumanizing them. That's exactly, I think, what you're saying here. Yeah.
So, shall we open up
Yeah,
the floor to the questions from the floor?